Tony Perkins. Mr. Perkins is the president of the Family Research Council. He is a former member of the Louisiana legislature and a veteran of the United States Marine Corps. He received his undergraduate degree from Liberty University and his MPA from Louisiana State University. Mr. Perkins, your entire statement will be read in the record, and you may proceed.
Thank you, Mr. Chairman, Ranking Member Sessions, and the remainder of the committee, Senator Hatch. Thank you for the invitation to testify. As one who spent a number of years in uniform as a Marine and a police officer, my remarks will focus primarily on Ms. Kagan's treatment of military recruiters at Harvard Law School. As has been pointed out, while Dean of the law school, she defied the requirements of federal law known as the Solomon Amendment. Her violation of this federal law was motivated by her vehement opposition to the military's prohibition against open homosexuality. This protracted incident, combined with the just-made public report of her rewriting of the medical findings of ACOG on partial birth abortion as an advisor in the Clinton White House, raises doubts as to whether she possesses the requisite judicial temperament and impartial nature required of a Supreme Court justice. On the former topic, when Ms. Kagan did comply with the law, she wrote to the campus, making clear just how grudging her cooperation with the military was in light of the military's quote-unquote repugnant policy. She declared, quote, "I abhor the military's discriminatory recruitment policy," and she added that the policy was a profound wrong, a moral injustice of the first order, end quote. A moral injustice of the first order. Of all of the moral injustices throughout history that man has inflicted on man, she equates them to a military policy enacted by Congress. Mr. Chairman, the purpose of our military is to fight and win this country's wars. War is the most difficult human activity, bar none. It requires organized groups of men and women to act with strategic and tactical lethality while its members are simultaneously being wounded and killed. In war, the normal ways of living are completely sacrificed in the harsh, punishing environment of combat. Even in peacetime settings, in units not engaged in combat, great sacrifices are required. Military life, by its nature, must be characterized by regular lack of privacy and repeated situations of forced intimacy. As military experts have testified, and this Congress has affirmed, in such an environment, it is not a moral injustice of the first order to minimize the sexual exposure that such conditions force on soldiers, sailors, Marines, and airmen. It is the only sensible and effective way to run a military organization. It should be noted that the current law on homosexuality in the military has been repeatedly challenged and upheld by the federal courts, and the Supreme Court unanimously upheld the Solomon Amendment. Now, some have defended Ms. Kagan's actions regarding the military, claiming they do not demonstrate that she is anti-military. And there is truth in that, only in that she does not oppose the military simply because they are the military. However, clearly she does oppose the military because they have not yet bowed to the demands of the sexual counterculture. Her record would suggest that it is not that Ms. Kagan does not want the military to defend our nation against terrorism. It's just that she wants to use the military to advocate radical social policies more. Now, this becomes very clear when one examines the amicus brief that Ms. Kagan signed on to in the Solomon case. The brief began with a sweeping declaration that is startling in its implications. Quote, "We are deeply committed to a fundamental moral principle. A society that discriminates based on sexual orientation or tolerates discrimination by its members is not a just society," end quote. Note that Kagan and the professors condemned not only a society that discriminates, but a society that tolerates discrimination by its members. Now, I abhor discrimination based on race and other immutable characteristics, but the implications of this statement are chilling for the freedom of speech and the freedom of religion in America. It should alarm those who live in the 45 states that define marriage as a union of a man and a woman, and to the tens of millions of Americans who affirm biblical moral teaching. Her own statements make obvious that Elena Kagan would strike down any marital statute, including the Federal Defense of Marriage Act, which defines marriage as being the union of one man and one woman. At question is not whether Ms. Kagan is a good person, or even if she is skilled in the law. What is in question is her ability to be an impartial jurist. Her record makes clear that she is an impassioned activist, that only sees laws, and in some cases science, as mere obstacles to overcome in pursuit of a far-left agenda. We do not need a justice on the Supreme Court who sees it as her life mission to write the homosexual version of Roe v. Wade by striking down one-man, one-woman marriage all across America. These positions and the temperament accompanying them make her unfit to sit as an associate justice on the Supreme Court, and I urge the Senate to reject her nomination.
Thank you, Mr. Perkins.